Are non-binary persons protected from discrimination at work under the 2010 Equality Act? My name is Chris, and today we're going to discuss the landmark case of Taylor and Land Rover and how it has the potential to help define the status of NBs under equality law. As always, a little bit of housekeeping before we begin. So, when reading the law, it's important to understand the background and biases of the source of your information. In the age of fake news, I endeavour to make sure I tell you these things up front. I'm currently a postgraduate law student at the University of Sunderland with a research specialism in trans rights and employment law. I have an undergraduate degree in law from Oxford Brookes University, and in 2017 I was a finalist in the Legal Week Legal Talent Competition presenting on issues on non-binary discrimination in the workplace. I'm also a trans woman, which will mean, deliberately or not, I will have an unconscious bias towards trans persons and our NB friends, in this case the claimant, Ms. Taylor. However, for transparency, I will always post links to my sources in the description below so that you can read them and draw your own conclusions, which I invite you to discuss in the comments below. Just be respectful. This is a place of love and academia, not blind hatred. As any good law student would, and since this is essentially a video essay, I'll start by outlining the background to the case, then talking about the court's decision, after which I'll provide my own commentary and conclusion based upon the facts. Miss Taylor had worked for Jaguar Land Rover for 20 years as an engineer. She previously presented as male, but in 2017 came out as gender fluid and began presenting as female and using feminine pronouns. For those who may not understand the term gender fluid, it's a subsection of the non-binary community that typically experiences a fluid relationship with traditional gender stereotypes. I explain this more fully in my video discussing the Equality Act itself, which is linked in the description, and might provide useful background information on this case for non-lawyers. After coming out and changing her presentation, Miss Taylor was subjected to insults and abusive jokes at the hands of her colleagues, as well as experiencing difficulties with the use of toilet facilities on the Jaguar Land Rover premises at which she was based. Her claim was brought under allegations of harassment, direct discrimination and victimisation on the grounds of gender reassignment under Section 7 of the Equality Act. As a brief trigger warning, I'm going to give you examples of the kind of abuse that Ms. Taylor experienced as described in submissions to the Employment Tribunal. Ms. Taylor's line manager, a Mr. Poole, is reported to have commented pejoratively that she was not normal, asked her not to dress in a feminine manner at work, and told her to use the disabled toilets. It is noted in the case, however, that Mr. Poole had only made the latter suggestion because he was aware that this was advice that a HR manager at the company had given to another trans employee and had assumed it was correct. For the record, it isn't. It infers that the protected characteristic of gender reassignment under which this case was heard constitutes a disability, as well as taking away access to disabled facilities for employees with actual disabilities. On June 30th, 2017, she reported a colleague saying, "I checked out your dress, looked up, saw it was you, and my jaw dropped." The claimant, in context, found this comment upsetting and offensive, and it can be inferred that the remark was not meant as a compliment. In fact, in a completely different context, this could even have been inferred as sexual harassment. On July 10th, another colleague is reported as having asked Ms. Taylor, and I quote, "What's going on? Are you going to have your bits chopped off?" Quick sidebar, not only was this offensive to the claimant, phrasing a question this way will be very offensive to every trans person. Someone's genitalia is only your business if they intend to sleep with you or you are their doctor. Sure, we might have these conversations with friends, but the clue here is the word friends. If one of my friends asked me this question, I'd know there was no harmful intent behind it. If a stranger asks that question, I don't know why they're asking it, but I can only assume it isn't for a positive reason. On August 7th, the claimant overheard a conversation between two male colleagues where the first asked, in reference to her, "Have you seen it?" To which the other replied, "I saw it in the atrium." Just so we're clear again, and it literally states this in the report, a human being is never an it. Nobody chooses the pronoun it, and it will always be offensive. She was told by human resources not to be so sensitive. And yes, that's a direct quote. Now, this is just a small sample of the abuse she received, much of which centered on her outfits, including being asked if it was Halloween, and a long string of records of HR personnel being deliberately obstructive or unhelpful. In the end, she felt forced to resign her position to escape the abuse, and when she later tried to withdraw her resignation, the company rejected her attempts. The issue at play in this case was whether or not Ms. Taylor qualified under the protected characteristic of gender reassignment under Section 7 of the Equality Act. Jaguar Land Rover argued that she didn't, as non-binary or gender-fluid persons are not explicitly named as protected under the Act. So, what did the Employment Tribunal have to say? The Tribunal decided, unanimously, that Ms. Taylor was protected under Section 7. Moreover, they described all of her allegations of discrimination based on gender reassignment as well-founded. Although they rejected claims about homophobic abuse and harassment based on time limitations, they were also found to have merit. Her claims of direct discrimination and victimization were also deemed well-founded, and Jaguar Land Rover's attempt at statutory defense was summarily rejected as without merit. Finally, they held that Ms. Taylor was unfairly dismissed. Jaguar Land Rover were ordered to appoint a diversity and inclusivity champion, to commission a report from a recognised diversity organisation, with Stonewall being suggested, and for this report to be compiled annually for the next 5 years and released publicly to employees and to the claimant. Finally, they were ordered to pay Ms. Taylor £180,000 in damages plus legal costs. So why is this case important? The legal status of non-binary persons under existing discrimination law has only been tested once before now, in the case of Elan Kane and Home Office, and never successfully. While the Elan Kane case, however, was in reference to gender identity on government-issued identification documents, this is the first case in which a non-binary person has successfully defended their rights in general, and certainly in an employment context. For that reason, I fully expect this case will be, at the very least, taught by law lecturers across the country for quite some time. In fact, that was how I came into contact with this case, because one of my lecturers sent it to me to read. However, in a practical legal context, this is only a victory in a battle, not the greater war for legal recognition of NBs. Employment tribunal decisions are not binding precedents. They do not have the ability to be used to enforce legal change. A case like this, with the publicity that surrounds it, will act as an incentive to other companies to reconsider how they approach these situations and to avoid challenging claims at tribunal for fear of bad publicity. And as much as I would never encourage anyone to not defend a case in which they genuinely believe they've done nothing wrong, a company would rather settle the case and sweep it under the rug than suffer from bad publicity, or indeed and ideally to avoid a case ever arising at all. So links to my sources are in the description below. If an argument doesn't have a corresponding source, it's safe to assume that I'm the source of the argument. Don't forget to like, subscribe and ring the bell, and let's get a discussion going in the comments. Remember to be kind, this is a place of love, not hate. If you have any requests or suggestions for issues, cases or legislation you'd like me to discuss, feel free to mention that in the comments as well. And until next time, I've been Chris and I'll see you very soon. Take care.